Juvenile Court and Education, Consequences You Should Know. This short web tutorial is designed to give a broad overview of the intersections between juvenile court, education, and school discipline, and the legal rights of students and their families. This tutorial is generously funded by a grant from the Office of Juvenile Justice and Delinquency Prevention of the U.S. Department of Justice. Today's presenters are Karen Pillar and Nicole McGrath.
The key points to remember about juvenile court and education and the consequences you should know include, at every stage of a juvenile case, the student's educational needs matter. Schools can impose discipline for behavior that also leads the youth to juvenile court. When students come into contact with juvenile court, their education can suffer. Advocacy and attention is needed to make sure students who have contact with juvenile court can succeed in school.
Juvenile defense attorneys should consider ways a juvenile case can interfere with and impact a child's education. Why does the education topic matter at juvenile court? And education is recognized as a protective factor which can help lessen the child's contact with juvenile court. A child's education is a key factor at juvenile detention review hearings, at criminal suppression, 3.5 or 3.6 hearings, and juvenile adjudication or sentencing hearings. A youth's ability to attend school can mean the difference between success on juvenile probation or being in violation of a court's order, and then subject again to the possibility of more juvenile detention. To fulfill the duties of rehabilitation for a child involved with juvenile court, the defense attorney, judge, family members, and probation need to make sure the child is enrolled in school and receiving an education appropriate to meet the child's needs, including any special education needs.
Another reason why school matters has to do with which children at juvenile court more often lack access to an education. Children with disabilities and children of color more often are suspended or expelled from school. Raising patterns of inequity by a local middle or high school can be relevant at a child's juvenile detention review hearing, criminal suppression motion, or juvenile adjudication, otherwise called sentencing hearing. Am I seeing pausing?
Oh, I'm sorry. I was talking to you guys. My phone was muted. Did you? That was fantastic. You guys are really good readers.
I know I had a little bit of a slip or something in there, and I don't know how much it matters to you as far as just the perfection of, it would be somewhat natural, I think, in just a speaking situation. You might slide a word. Brains are different than adults' brains. Adults, including families and caregivers, judges and court staff, and juvenile defense attorneys, should consider these differences when working with youth in the juvenile justice system. Education records are critical tools for defenders to review and consider to establish possible defenses, mitigation strategies, and to understand the unique needs of the adolescent client.
Children and youth are different from adults. There has been a great amount of research conducted to demonstrate the differences in the adolescent brain and how adolescents think and act. During adolescent development, a youth's brain has not completed development. The brain of a male adolescent generally reaches mature development around age 25. The time of adolescence, from about age 12 through early 20s, make children and youth both prone to risk-taking and capable of rehabilitation. What's going on at school can inform the juvenile offender attorney and others who work with the youth about unique disabilities the student may have and what supports and interventions the student is receiving at school. Tips for attorneys: be alert as cases come into the juvenile court for situations where alleged crimes took place on school grounds and facts indicate the police and/or school staff engaged in restraint and detention of a special education student. A student's behavior issues, when related to the student's disability, lawfully requires schools provide a host of protections and services to help manage the behavior need. For example, the school is supposed to have a plan in place called a behavior intervention plan to direct staff on how to de-escalate situations for each individual student.
Also, traumatic experiences have a profound effect on learning and brain development. Schools are beginning to embrace new ways of supporting the social and emotional needs of youth through programs like positive behavior interventions and supports, or other multi-systemic support programs. The courts can incorporate these approaches when working with youth who have experienced trauma.
Have a right to an education, even if they're involved in the juvenile justice system. These rights are in our Washington State Constitution. The right to an education extends to children held in juvenile detention, including the pretrial stage of the juvenile case, and after juvenile adjudication, also called juvenile sentencing. This means that when children are in detention facilities, education services or school will be provided in the detention facility. Special education services will also be provided to youth who are held in detention facilities.
A student may be disciplined, suspended, or expelled from school for violating school rules as defined by the school district. Suspension or expulsion from school may result from criminal or non-criminal types of misconduct. Sometimes, when kids are arrested and charged with crimes outside of the school environment, they will still face disciplinary action from their school, including suspension or expulsion. But the law guarantees that a student's right to education continues during a period of suspension or expulsion from school. School districts may not stop providing educational services to a student as a form of discipline. A student may be excluded from a particular classroom or school while suspended or expelled, but the school district must provide an opportunity for the student to receive educational services during the period of suspension or expulsion.
Students and families and advocates can challenge school disciplinary decisions and can challenge any time a school denies a student enrollment at a school due to juvenile justice involvement. Here are some basic rules about school discipline. A student may be disciplined, suspended, or expelled from school for violating school rules as defined by the school district. Suspension or expulsion from school may result from criminal or non-criminal misconduct and sometimes from behavior that occurs outside of the school environment, especially if that behavior leads to an arrest and charges in juvenile court. Suspensions may be short-term or long-term. A short-term suspension is for up to 10 consecutive school days, where the disciplinary action involves a long-term suspension, more than 10 days, or expulsion, the end date of the disciplinary period cannot be later than the end of the academic term. Are almost never required to use suspension and expulsion as a form of discipline. The only place in state law that an expulsion is required is when a student brings a gun to school. However, long-term suspension and expulsion is permitted when students commit a variety of criminal offenses. Schools cannot use long-term suspension or expulsion to respond to unwanted behavior or violations of school rules outside of this list of criminal violations. There are some additional restrictions schools can impose for certain behavior. A student who commits assault, kidnapping, harassment, or arson, when it's directed towards a teacher, cannot be assigned to that teacher's classroom again in any school where the teacher is assigned. A student that commits any of those offenses against another student may be removed from the classroom of the victim for the duration of the student's school attendance at that school or any school where the victim is enrolled.
Anytime a student is suspended or expelled, the school district is required to hold a re-engagement meeting to discuss ways for the student to stay on track. Re-engagement is a process designed to reduce the duration of a suspension or expulsion after it has been imposed. School districts should make efforts to have suspended or expelled students return to an educational setting as soon as possible. School districts are required to convene a re-engagement meeting with the student and his or her parents or guardians within 20 days of a long-term suspension or expulsion and no later than 5 days prior to the end of a suspension.
Students and families to know that schools will be notified of any youth arrest or juvenile adjudication. Arrest or decision to arrest. After any arrest or decision to arrest, the police or prosecuting attorney may give to a school any information pertaining to the investigation, diversion, and prosecution of a juvenile attending school, including any incident reports. Juvenile adjudication. The principal of the school must be notified of an adjudication based upon a statutory list of crimes. A juvenile adjudication occurs after the juvenile has either been found guilty at trial or pled guilty to a crime and receives a sentence from the juvenile court. A juvenile sentence is meant to punish and equally provide the youth an opportunity for rehabilitation. The principal must give information received pursuant to the above notification to the student's teachers, persons who supervise the student, and anyone else the principal deems necessary for security purposes. A youth's involvement in juvenile court can have negative consequences on a student's ability to access their education. An arrest can lead to the school issuing a suspension or expulsion. This will remove the student from school and create a school discipline record. As discussed earlier, certain criminal charges and convictions can also lead to school suspension or expulsion. Every time a student is removed or excluded from school, their education is interrupted.
Detention also disrupts a student's education. Longer stays in juvenile detention can lead to a school disenrolling a student from their community school. When a student is released from detention, the student may have to re-enroll in their school, which can delay a student's return to school. Placing a youth in juvenile detention often disrupts the student's educational progress. The education a student has access to in juvenile detention might not be aligned to what the student's education program is at their community school, especially for special education students receiving specially designed instruction and services. The credits a youth earns in detention may not easily transfer back to the student's community school.
There are other consequences on students when they have juvenile justice involvement. For example, every time a student has to attend court, the student misses a day at school. It can be very hard to catch up and very disruptive to the student's education.
Also, a student involved in juvenile justice may be stigmatized by some school staff. A student may then feel labeled as a juvie kid, which can feel defeating for a student who is trying to get back on track after having to go to court. Students who are coming and going from court, detention, and school are having a lot of school disruptions, which can make academic success more challenging. There are some important ways juvenile court can impact your education. For example, if you play sports, there are several impacts your court case can have on sports eligibility. Eligibility to participate in school athletic programs in Washington is governed by the rules of the Washington Interscholastic Activities Association, otherwise known as WIAA. It's also governed by individual school districts and individual schools. Drugs, for example, are an area where your sports can be impacted. Students will be disqualified from participating in sports programs if they're found guilty of possessing or selling drugs. The ineligibility continues for the remainder of the year for the first violation, unless the student accesses a community or school assistance program. In order to be eligible the following year, the student must meet with a sports eligibility board. A second violation requires ineligibility for 1 calendar year, and a third violation results in permanent ineligibility. School districts and schools may have their own eligibility policies, as long as they're not inconsistent with the WIAA rules. WIAA rules do not specifically address other criminal activity. However, the rules do require eligible athletes to meet academic and attendance requirements. School districts generally have codes of conduct which, if violated, may preclude sports eligibility. For example, school districts may have ineligibility rules regarding the possession or use of alcohol or unsportsmanlike conduct. Furthermore, being suspended or expelled can make you ineligible to play school sports.
Your juvenile court case may impact your college plans. Some Washington colleges use an applicant's criminal history to inform who gets admitted into college. In addition, a student's criminal history may negatively impact the student's ability to one day obtain a professional license to work in different kinds of professions. For example, students who want to work in early childhood education, teaching, or healthcare must show that they are not legally banned from having contact with people considered vulnerable, such as children and the elderly, and often require criminal background checks for participation. The common application used by many private schools around the country does not ask about prior convictions or adjudications. However, it requires a teacher evaluation and school report, which may disclose conviction adjudication information. In Washington, each private college or university treats an applicant's criminal history differently. Some ask the applicant about his or her criminal history directly. Others do not ask the student, but expect the information to come from teachers or counselors. Eligibility for the Washington State Needs Grant is not affected by juvenile criminal history and is determined through the federal application for financial student aid called FAFSA application, which excludes juvenile arrests and adjudications from being considered. Fortunately, juveniles convicted of drug offenses do not fall under the Higher Education Act's ban on federal financial aid. Only those convicted of a drug offense while receiving federal student aid are now suspended from receiving federal student aid. If a student is not convicted while enrolled, there should be no suspension of financial aid. Additionally, a person may not claim the tax benefits of the Hope Scholarship credit for an academic period if he or she has been convicted of a federal or state felony offense consisting of the possession or distribution of a controlled substance before the end of the taxable year, with or within the academic period ends. The student may receive a waiver if the student successfully completes an approved drug rehabilitation program.
Key points to remember about collateral consequences of juvenile court on a youth's education. At every stage of a juvenile case, the student's educational needs matter. Schools can impose discipline for behavior that also leads a youth to juvenile court. And when students come into contact with juvenile court, their education can suffer. Advocacy and attention is needed to make sure students who have contact with juvenile court can succeed in school. For additional helpful information, there is material available at the right side of the screen. You can either download a document or click a link to read and learn more.